Illinois. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. This is attorney Matthew Noyce, and I'm one of the partners at Perronick Caulfield, Illinois, that come here every Tuesday from 5 until 6 as a live legal call-in talk show. We are here to answer questions that you have for the next hour. We are here to answer any questions that you have. I specialize in personal injury, auto accidents, slip and falls, and other personal injury types of matters. Also workers' compensation and Social Security disability claims. But I'm not here alone. I also have my good friend, my law school buddy and buddy since then, Dennis Moses is here. Dennis, thank you very much for coming on our show tonight.
Well, thank you very much, Matt. It's certainly great to be here. Always good to see you.
Oh, it is.
I was just thinking we graduated law school 28 years ago.
That is amazing. You know.
It seemed like it was just yesterday.
And we did a radio show.
We did.
Yeah, you used to have a radio show. Your firm did.
Yeah, and you were one of my first guests.
It was a lot of fun. So this is like the circle coming right back. So Dennis, thank you very much for coming. Dennis is an attorney who handles all types of trust, wills, and probate and estate planning type of matters. So if you have questions regarding wills, trust, or estate planning, Dennis is here for the next hour. He's here to answer any questions that you have. The number is 727-441-3000. And we are also live on the firm's Facebook page. That is Perronick Caulfield, Illinois Injury Lawyers. We are here live on there. So if you don't want to call in with a question and you rather just send a text or a comment with your question, I'm looking at the page right here, so I'm able to ask your questions that way as well. So before we get started, Dennis, why don't you tell our listeners a little bit about you and the areas of law that you handle?
All right. Yeah, being in Pinellas County here, a lot of the listeners are familiar with the law firm of Joseph Pippin. Joe Pippin had a radio show for 37 years, the longest running radio show in Florida. But unfortunately, he passed away a couple of years ago, and the firm's under new ownership now. But we're trying to do everything the way Joe did it, and we're offering us free consultations, estate planning, wills, trusts, probate services, that sort of thing. And we have several offices around. As I said, Matt and I graduated at the same law school 28 years ago, and he's been in personal injury. And I went to work with Joe, and I've been with him for 26 years doing estate planning.
And what's really cool also, if I remember correctly, my dad used to have an office at Joe Pippin's office.
That's correct.
And I think
I moved into it right away.
Yeah. And my dad was a financial planner, and he had an office right there. And you know, if anybody could take my dad's office, I'm glad Dennis took it. So yeah.
Well, he was a wonderful man.
Yeah, Joe was a wonderful man as well. He was the most appeared guest on our TV show, FLA Law.
I remember, yeah. He really enjoyed doing that.
Yeah, it was good to have him there. So, but you have been carrying on. You've been doing what he's been doing for decades now. And so why don't you
Make
just
me
give
feel old.
Well, you and I are about the same, so that's all right.
No, I got beat on you here.
Oh, I just celebrated my 40th high school reunion this past weekend.
And I got a 50th coming up.
Oh, it's a great weekend. The good thing about it, I guess, is if you do it for 2 days, it lasts for about 4 days because you're so sore and trying to recover from the 2-day.
You see a lot of people you haven't seen in years and years.
Yeah, it was really fun. It was really, really good time. So I talk about estate planning and trust and wills, but can you give our listeners what does estate planning really mean?
Yeah, so really there's 3 different types of estate plans. There's those folks that have a will as their primary estate planning document. And the second one is those people that have a living trust. And the third plan is actually the do nothing plan. People decide to do nothing for various reasons. You know, why do people do nothing? Well, they don't have to come see me or an attorney or spend money to let the kids worry about it one day. Well, the problem with that estate plan is if we do nothing, then it's up to the children to try to put everything together one day. Usually when there's a crisis, then I get a call when you need to see mom or dad in the hospital or a nursing home. You know, that's not the time to do these things. The time's now when we're able, when we still can get around and think about things. So if there's just one area that I can leave you with, if you're in that do nothing plan, something definitely is better than nothing. So we'll let that estate plan go. Talk about wills a little bit here.
Yeah, why don't you tell us a little difference between a person getting a will and a person getting a trust?
Yeah, so there's 3 disadvantages of having a will. The first one's probate. If you've chosen a will as your primary administration, you've chosen probate as your administration. Probate costs an awful lot of money, takes an awful lot of time.
And that's going to court and everything, right?
Well, that's what some people believe, but actually most of the probate fees are attorney's fees. So why does an attorney write a will? Well, I don't know, but maybe hoping to see it again at some point. And the attorneys justify the whole probate process based on the time that it takes. On average, 6 to 14 months. It seems like it's taken longer and longer and longer to get through the whole court system. So then if you've chosen a will as your primary document, you've chosen probate as your administration, probate costs an awful lot of money, takes an awful lot of time. The second disadvantage of having a will, if you have a will and that's all you have no guardianship plan in place. God forbid you were to become incapacitated. A lot of people bring in their wills to me. They say, well, Dennis, if I become incapacitated, my executor in the will here will take care of things. Not true. An executor's job doesn't start till somebody actually passes on. And do you realize about 60% of the people in this country over the age of 65 have done absolutely nothing?
Oh, my goodness.
Yeah, and the chances are that, we will become incapacitated. I know it's happened in a lot of families. It's happened in mine. I've lost my dad a few years ago, but 3.5 years before he died, he had a major stroke where he couldn't walk, couldn't talk, couldn't do anything. Mm-hmm. But if all he had was a will, we couldn't do anything for him. But fortunately, he had his estate plan together where we could pick up the pieces, take care of Dad, take care of his finances, take care of everything. So the second disadvantage of having a will by itself, we have no guardianship plan in place. And then the last disadvantage, wills are public documents. When somebody dies, we're required to file a last will with the court. So what does that mean? Well, if there's an estate open, everybody can see what's going on, who's getting what's going where, everything's public knowledge. And in Florida, the statutes say that whoever holds the last will needs to record it within 10 days of death. And a lot of people don't know that. Even though there's no probate, the last will still has to be recorded. So then 3 disadvantages of having a will by itself. We have to go through the probate process. Costs an awful lot of money, takes an awful lot of time. Second disadvantage, we have no guardianship plan in place. And then the last disadvantage of having a will by itself, wills are a matter of public record. So how do we turn all those negatives into positives? That's the third estate plan. We start talking about living trusts. So with a living trust, what actually happens, we eliminate probate because having a living trust provides for fast and easy administration of a person's estate. All those probate fees associated with wills, gone. The time that it takes to settle the estate, much, much less. In fact, I've seen many estates distributed, settled, over and done with in just a matter of days.
Wow.
Why put our families in a situation day in, day out, working with the attorneys, going through the courts, when all that can be avoided? So the first advantage...
So you're talking about months and months and months through the probate process as opposed to
correct
weeks through the trust process.
That's
wow.
Correct.
Well, wonderful.
And a lot of money saved in the estate as well. So we can eliminate probate. The second advantage of having a living trust now, back to guardianship planning. With a living trust now, we have a built-in guardianship plan because we choose successor trustees to step in behind us. We are the trustees of our trust now for as long as we can, but if it ever came to the point where we couldn't serve as a trustee, whoever we choose next in line, could be family, children, whoever, could automatically step in as a trustee of the trust, pay our bills, manage our assets, do the things we're used to doing for ourselves, all without having to go through a guardianship.
Yeah, so the will is just a piece of paper that doesn't have anything to do with it until somebody dies. But
that's correct.
The living trust is a document that can be utilized even when the person is incapacitated but still alive.
So
right?
if a person does become incapacitated, what's required, according to the trust agreement, is whoever the successor trustee is, they just need to get 2 doctor statements saying that they can no longer take care of their financial affairs. And with those 2 doctor statements, that automatically puts the successor in as the current trustee, and that person can manage on and do everything that his parents or whoever it was wanted them to do. And then lastly, Remember, wills were public documents. With living trust, the estate is privacy. Nobody's going to see what's going on in our estate except those that we want, our successor trustees and our beneficiaries. So those are the three estate plans. Obviously, I think living trusts are the best way to go, and they are for most people. And some people say, well, you have to have a very large estate in order for a living trust to make sense. Well, that's not true at all. In fact, if a person's estate's greater than $75,000 in Florida, if it has to go through the probate administration, it's a formal probate. That's the one that takes all the time. That's the one that costs all the money. So that's kind of the break-even point. Estates less than $75,000, we could do something called a summary administration, which is faster, which is cheaper, but estates over $75,000.
And you still have those other problems that you have about being public and,
that's correct.
And the delay.
That's correct.
Let's see if you have questions regarding the difference between a will and a living trust. That's what we're here for. We're here till 6 o'clock. And our number is 727-441-3000.
And we've already got people utilizing said phone number. Kim from Clearwater is on the line.
Hi, Kim. Thank you for listening. What question do you have?
Hi. Yes, I just had a question. If a spouse dies, is the surviving spouse responsible for all the medical bills incurred by their dying spouse?
Question is, person dies and they're married. Is the spouse responsible for the medical bills? Yes and no. No, if the spouse doesn't sign for or guarantee them, the spouse is not responsible. But another plus for having a living trust versus a will, with a will, if we have to open up an estate because of probate, now creditors are notified. If there's outstanding bills, outstanding creditors, they all submit claims, so that'll reduce the estate. So if we can eliminate the whole probate procedure, generally that avoids, creditors being able to come back at it.
So if they didn't do the living trust, but they did the probate process, if there's nothing in the estate, then medical providers...
Yeah, then the estate can't.
The spouse doesn't have to pay for those medical bills.
No, but even if there isn't a probate, what we just recommend to our clients is just send whoever's sending the bill, a copy of the death certificate, and that should do it. Good question.
Kim, thank you. Did that answer your question?
Yes, thank you so much.
Thank you for listening. We appreciate that. It does free up a line, and so our number is 727-441-3000. I am Matthew Noyes. I'm a personal injury attorney, workers' comp attorney, and Social Security disability attorney. So I can answer any questions that you have regarding those areas of law. But my special guest today is Dennis Moses. He's a wills, trust, and estate planning attorney who's been doing it just as long as I have. We walked down the aisle. We walked down the graduation aisle together. And so...
And the orientation aisle.
And the orientation, that's right.
I was going to say, if he walked down the aisle with you, how did your wife feel about this?
That's right.
Does she even know about this?
Oh, she understands.
Yeah.
I was going to say, I would hope so. Well, Mrs. Noyes, if you don't know, now you know. We have it on audio record.
Yes. Dennis and I met the first day of law school. We were standing in the orientation hall together.
Yeah.
And I was lost as can be. And I guess Dennis was looking for someone to help. And he and I became friends right that day.
It was actually my second career being an attorney. My first career was being a banker. And I decided, well, I didn't like the way things were going in the banking field. So if I was going to make a change, I ought to go ahead and do it. And then as we're standing in that line, I'm thinking, what in the world have I done?
You did banking for a long time too, right?
Yeah, 13 years.
Yes.
But it's been a lot of fun. And it's great. Just like Matt, he loves to help people. And, those that have problems and situations, that's what we're here for. Yeah. That's what we're here for you right now.
Yeah, and I unfortunately get to meet a lot of wonderful people after something bad happens to them, whether it's a car accident or a work injury or something else. But you also can have that situation. A death happens, but really you can meet good people even before the death happens, and that's the estate planning that we were talking about.
That's correct. And it's usually the children that we hear from. A little bit of planning for mom and dad makes their life so easy, and everything just goes so well. After they pass on, and it's usually the children we hear from. It's hard enough losing mom and dad, but man, everything was really so easy, and that's the way we try to make things.
Yeah, and you talked about a living trust, but I've also heard the term living will. There's a difference between a living will and a living trust, right?
Correct. And maybe if it's okay with you, we'll just talk about what documents a person ought to have in their estate plan.
Perfect.
So if a person's a candidate for a trust, they should have a trust. The trust agreement, it's revocable. What we're talking about this afternoon is a revocable trust. That means everything still belongs to us. We're still in control of everything. Even with the living trust, though, we need a will. It's a special kind of a will. It's called a pour-over will. I had a lady at a seminar once say, what's the name of that kind of will? A spillover will or something? Well, same idea, because having a living trust is a two-step process. The first step is we got to create the document. The second step, we have to fund it, because having a living trust without putting anything in it, you might as well not even have it. So what are we talking about? Well, there's certain assets that we actually own that actually needs to be retitled to the name of the trust in order to get the benefits that we talked about to avoid probate and all of that. So what assets need to be retitled to the trust? Well, our bank accounts, checking accounts, savings, money markets, CDs, all those bank accounts get retitled to the trust. So how do we do that? Well, it's easy. We just take our trust agreement over to the banks. They'll copy what they need out of it, and they'll go ahead and retitle all those accounts into the name of the trust. Stocks, bonds, mutual funds, savings bonds, brokerage accounts, all those gets retitled to the name of the trust. Real estate, our home. And some people say, I don't really have anything except a house here. Well, if the house has to go through probate, that can be a $3,000 to $5,000 expense or higher.
Wow. Yes.
But by deeding it in the trust, we can eliminate probate on the house.
But if you deed it into trust, do you lose the homestead exemption?
Absolutely not, because
Okay.
we still own the house. The trust is us.
Okay.
So you still get the homestead exemption. And when you get a living trust, you don't even notice that anything's different because you just keep doing things the same. But back to the pour-over will. Let's say there's an account out there, should have been in the trust, never got to the trust, and that person dies. Well, upon death, that account would actually pour over from the will. It'll get it to the trust. But if it has to go through the will, it still goes through probate. So that's why it's important with your financial person's help, with your attorney's help, that everything that belongs in the trust gets there, so that the will's only used for personal items and vehicles, and there's no probate on those. So
like
vehicles don't need to go into the trust.
Like the tangible property that they own and such like that, the furniture and all that stuff.
All the stuff that we have that probably nobody else wants, but we think it's all so important.
Yes.
But in Florida, how that's handled is by use of a separate writing, which is an attachment to the will, where a person can actually fill it out, sign and date it. If there's a special ring or something they want a particular person to have, that's what they'll put on that.
Okay. Because some people think that you can only put that in the will itself.
Yeah, we recommend that we don't, because if things change and we got to keep redoing the will.
Right.
So a person can just use that separate writing and keep it updated themselves.
Good.
Next document, everybody should have a durable power of attorney. Probably the most important document out of all of them, where a person gives power of attorney to whoever they want, no restrictions. That person can do anything of a financial nature, handle bank accounts, investments, sell a house, sign the person's name, whatever. You really got to make sure you have the right person to do that. And most people, have their families, sons, daughters, or whatever. Plus, the power of attorney can also make healthcare decisions if that person can no longer do that themselves. Can enforce their living wills. And we have a pre-need guardian provision in there, which just means if a court ever determines that a person needs a guardian for whatever reason, we're choosing who that person should be now, rather than a court or a judge or anybody else making that decision for us later.
Oh, that's interesting.
Wills take effect when we die. Power of attorney documents are only good while we're living. And that's the one document that can and will become stale at some point. We notify our clients like every 3 to 5 years when it's time to update that document, because it's such a powerful document that banks, financial institutions, and others, they want to keep those current. They want to make sure, say mom did that 15 years ago. Well, how do we know that mom still wants to do that now? Give you that kind of authority. So usually 3 to 5 years, we like to update those documents.
Oh, okay.
And then the last document, Matt, you mentioned was a living will. That's the document where, say, we had a heart attack. We want the paramedics to come out. We want them to do everything they can possible to bring us back. But after they tried everything, basically we're left in a vegetative state for all practical purposes. There's no life, nothing they can do, no chance of recovery. then we're just authorizing the medical field stop all the life support heroics and all of that.
And that's the living will.
That's the living will.
Okay.
And I've seen a lot of living wills issued by doctors, hospitals, whatever, that says absolutely nothing. If it's your desire, you don't want life support in certain situations, make sure you have a strong legal document with teeth in it, because the last thing the medical field is going to want to actually do is remove life support from somebody if they think there's a good chance maybe somebody can go back at them for doing that.
Yeah, so some of the hospitals have it just as a quick little form.
Right.
You recommend that, as part of the estate planning, have that document reviewed by you or somebody who does estate planning.
Correct.
All right. Well, it does look like we do have another caller on the line.
We do. It's Cindy from St. Pete.
Cindy, thank you for listening and thank you for calling. What's your question?
Yeah, my question is, if you have a trust, do you have to obtain a will as well?
Yeah. We just kind of covered that, but the will is a special kind of will. A lot of people say, well, I already have a will, so we don't need to do one for you. If you get a trust.
What you hear is they always ask you, do you have a will? They never say anything about a trust.
Yeah, but the will kind of works in conjunction with the trust. That's that pour over will we talked about. So if somebody left something out of the trust that should have been there, that will names the trust the beneficiary, and that gets it to the trust to where the trustee has access to those, assets. So, and it also takes care of vehicles and personal items and things like that. So the person still needs a will even with the trust. So
Okay.
It's that pour over will.
So if they have a living trust, but they don't have that pour over will,
They need to get that.
then the car that they may have that's not into the trust ends up having to go through probate and testate, right?
Correct. But if a person has a vehicle, and we don't always recommend that they go ahead and put that in the trust. It's not necessary, because when somebody dies, all the executor of the will has to do is take the death certificate, the title, and the will to the tag agency, and they'll transfer it over.
Oh, okay.
So there's no probate on the vehicles.
Okay.
All right, Cindy, was that helpful?
Very helpful. Thank you so much.
Good. Thank you for listening, and thank you for calling in. We do appreciate that. We're about to take our first break, but let me give you the numbers again before we take our break. The number to call in is 727-441-3000. Too many times the callers wait till the way end of the show, and we can't take all the calls. So think of your question, give us a call during this break, and we'll be right back. Thank you.
This is the Tan Talk Radio Network.
In 1955, the law firm now known as Pernick, Caulfield, Averill, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Pernick, Caulfield, Averill, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the Tan Talk Radio Network.
We are back. This is attorney Matthew Noyes, and you are listening to FLA Law on the radio. I am a personal injury attorney with the law firm of Pernick, Caulfield, Averill, and Noyes. We are the oldest personal injury attorney firm in Tampa Bay. We started back in 1955. Guy Pernick started the firm after being an insurance adjuster for a while and realizing, well, gosh, those people that are hurt are really being taken advantage of by the insurance companies. And so he was the first one to decide to only handle personal injury matter cases, and he's always put the client. He always put the client first, and he instilled in all of us that same respect to put the client first, to be a voice for the injured. We are in a legal system that sometimes there is no voice, and so we are proud to be the voice of the injured at Paranet, Caulfield, Averill, and Noyes. We are live on the radio. We are also live on our Facebook page. It's Paranet, Caulfield, Averill, and Noyes Injury Lawyers. So if you have a question and you don't want to be on the air, just type in your question right on Facebook, and we'll be happy to answer the questions. But I'm not alone. I have my buddy, my friend, a very smart attorney, Dennis Moses, here also to answer questions. Dennis handles all types of estate planning issues, including wills and living trust and power of attorneys and such like that. And really, that's really what I want to lead into, is that power of attorney that you were talking about, that durable power of attorney. Can you explain? We hear, would you have a power of attorney, or you sign a piece of paper when you're buying a car for a power of attorney? That's not what we're talking about. We're talking about something else, right?
Yeah, in Florida, we use a durable power of attorney, and all that means it survives incapacity. So if a person becomes incapacitated, that document's still good. It's still honored. And
so if it's just a power of attorney, it doesn't say durable power of attorney. As soon as that person becomes incapacitated, that power of attorney is void?
That's correct.
Oh, wow. Okay. Even more reason why you need to have an attorney help draft up these the important papers.
Exactly.
Wow.
That's what we recommend. And I always get questions, well, I can go to LegalZoom or go online and do all of this. Well, the only problem with that is, when an attorney does your estate plan for you, we document our files. This person came alone. There's nobody else with this person. This is what he or she wants to do. He's definitely of sound mind, that sort of thing. If somebody does it themselves, who knows if, one of the children are with mom or dad when they're doing that, and they're, coercing them or telling them what to do. And maybe I've seen situations where, parents eliminate some children. They just want to give everything to one child or a couple of them and take the others out. That's perfectly fine to do for various reasons. But let's make sure that none of the children are with the parents when they do that with the attorney.
Right.
So if somebody does it at home, there's no way to prove that, nobody else was with them or that sort of thing.
Right. And I remember way back when we used to do the TV show FLA Law, the most asked question on that show over the decades of doing that show was, I had a will drafted in New York or another state. Is it valid in Florida?
Yeah, that's a real good question. We hear that all the time. If you're a Florida resident, you really ought to have a Florida will. Statutes are different in every state, and we reference everything by statute. But back to a living trust. If you have a living trust, say, from New York, living trusts are good in all 50 states. So if a person moves, and what we recommend is that if they move to another state, they take their trust agreement to that attorney in that other state to review it and prepare an amendment changing the laws and the residents to the new state. But everything that's already in the trust stays. Everything's good that's already in the trust, so they don't have to retitle or do anything else.
No, that's interesting. I know when we talk about trust, and people are a little hesitant saying, well, gosh, I don't have enough assets for a trust, and we don't want to have trust babies and all that kind of things that we hear about. But that's really not the type of trust that the average person needs, though, right? I mean, if you don't have a lot of assets, a living trust is still important.
Yeah, very important. And that's the best way to make things simple for the children or our loved ones or whoever's going to end up getting everything. And but there's a lot of flexibility with trusts also. I had a lady come in once. She was like 93 or something, but she says, I guess it's time to do something. I said, well, it probably is, but she looked great for 93.
Oh, wow.
But she said, this is what I want to do. I want to leave to all these people. There were probably 20, 30 beneficiaries or whatever. And but she says, I want to go one step further. I don't want anybody to have anything till they become 65 years old. And I kind of looked at her and say, what in the world? She said, well, what's wrong with that? I said, well, absolutely nothing. It's your money. They're your assets. You can do anything you want. And when she explained it to me, Well, I want everybody to work hard, during their lifetimes, and when they get to retirement age, there'll be like a supplemental retirement income for them.
Wow.
Well, when you think of that, that's kind of a nice idea. Have everybody work hard during their lifetime. But the point is, we had a lot of beneficiaries, a lot of stuff going on in there. And, obviously there got to be a trustee that's going to be around that long to take care of it. She was already 93 and it's going to go on another few years. So in that case, who can serve as a trustee? Well, if you have a bank or brokerage house, attorneys' offices, they can all serve as trustees as well. So, but the point is, she came in the following year, she said, what, that was a lousy idea. Why should we keep the trust open that long? Just let's give it to everybody outright. So what do we do then? We just do a simple amendment to the trust, and everybody gets an outright distribution upon her death.
Oh, wow. So
it's very flexible.
Very flexible, easy to amend when it needs to be amended.
Yeah, and I have clients that come in, well, one child's great with money, the other's not. Well, what do? Well, we put the one that's great with money, make that person, say, the trustee, successor trustee, and that person can have an outright distribution. And the one that's not so great with money, we can put their share out over time.
Oh.
And the trustee can just divvy it out. And there's a lot of different flexibilities that we have with trusts.
So the trust is handled by the trustee and or manages what the trust tells them to do, right?
That's correct.
And while the person is alive, the trustee is that person.
Correct.
What happens when the person dies? Who should become the trust, or who should be named the trustee?
Well, that's in the trust document. The person that created it, the successor trustee, then steps in as the current trustee. So a person dies, the successor trustee with a death certificate automatically becomes the trustee of that person's trust, and that person's job is then to gather up the assets and settle the estate. And if the person that created the trust did their job right, get everything that belongs in the trust there, the successor trustee, who is now the current trustee, his job is very, very easy.
And is that similar to the role of the personal representative in the probate matter?
The only difference is the personal representative in the will, also known as an executor, just needs to work with an attorney to get the assets through probate to ultimately get to the beneficiaries.
And there's steps and hurdles that they have to jump through.
That's a costly probate process. That's a time-consuming process, right. And that's what we're trying to eliminate here.
So if somebody passes away, if they have a living trust, then it's just an even flow of what their wishes were with their assets.
That's correct.
As opposed to the probate, they die. You have to file the will with the court. And then you have to ask the court to appoint the person who was supposed to be the personal representative.
That's correct.
Wow. So there's a lot of legal stuff you have to go through when you don't have a living trust.
And then we got to publish a notice to creditors, and that's 3 months, and it just drags on and on.
Wow.
And we can eliminate a lot of that.
Wow. Now, there's some people that try to argue the validity of a will. You see that on TV a lot, that they try to argue the validity of the will. Can they do the same thing with the validity of a trust?
Absolutely. The courts are open to everybody. But, somebody has to have a really good reason to contest a will or a trust or whatever. And, if a person wants to leave, say, a child out because that person just never sees the child, you can do that. But how we work it, whether it's a will or whether it's a trust, it's always the best idea to mention that, this child's not to receive, and don't give a reason. And don't say because a person never called me on Father's Day, or I never saw him, or because then you die and it's just their word against yours. So we just say, no, we're making no provision for this person for personal reasons, period.
Right, because then they can dispute, well, no, I did see them on Sundays, or that was before.
Yeah, never give a reason.
Oh, that's a smart idea. That's a good lawyer advice there. See, on FLA Law on the radio, you get free lawyer advice right there.
There you go.
Thank you, Dennis. Dennis, why don't you also tell our listeners just a little bit about that durable power of attorney again? Why is it so important, and who should have that power, so to speak?
Yeah, obviously, power of attorney, husband and wife should probably have it for each other. Unless one of them is approaching dementia or something like that, then you may want to have one of the children. But it needs to be somebody that you can trust, that you can count on, because the durable power of attorney, as soon as that person signs it, it's in effect. So if that person actually has that document, they can actually become us. So it's very important that, we choose the right person, and usually our loved ones, we can count on them, but I've seen certain situations where even that backfires.
Right.
But it's probably the most important document out of all of them. But just make sure you have the right person to do that.
And that you can appoint a durable power of attorney and hold that for later. Is that right?
Yeah. So I always tell my clients it's not necessary to give that document to anybody. What's important is that the client puts it in a place. We recommend a safe deposit box, and make sure that the successor trustee signs a signature card at the bank, knows where the key is. And my instructions are so that make sure that person has access to the bank box. So if something happens to us, somebody can go in there, see what responsibilities they have at that time, and without giving them the document when they create it.
That's a smart idea. Well, although I'm a personal injury attorney, we do often have situations where we need smart attorneys like you, Dennis, because when our clients, God forbid, they get in an accident and somebody dies, it's a wrongful death claim. Whether if it's an auto accident, it could even be medical malpractice. It's a wrongful death claim, and the family are entitled to damages as well as the estate. And because we handle the personal injury aspect of the claim, we often turn to you and other estate attorneys to help us and help the family through the estate process. We can't do that alone. We need you all to do that, because if there's a recovery for wrongful death.
Right. So what we would do, we would open up the estate. So if there's any monies that's recovered, if there was a will or a trust or whatever, that person's wishes would be honored.
Right. And we also can't even file a lawsuit without the estate being set up, because we have to file it.
The personal representative has to be in charge of it.
Right. Right. So, but we also want estate planning also goes further along. And this is what I hear a lot of questions about. Is there a way to protect the assets if somebody needs to go into a nursing home?
Oh, that's an excellent question. Yeah, if a person needs to go into a nursing home, the children or whoever is going to be in charge of that should, and that's where durable power of attorney comes into play too, because we have special language in the durable power of attorney document that we can actually protect what's in a person's estate, qualify somebody for Medicaid for nursing homes, and make sure the assets are, preserved for the children and not to a nursing home. And all that special language is in the durable power of attorney document as well. And if somebody doesn't have the durable power of attorney, if that person's still competent and able to do it, we always have that person sign the power of attorney first. But most elder law attorneys have Medicaid knowledge. And in fact, our firm, we have a Medicaid attorney in charge of the Medicaid department that does nothing but protect assets, qualify people for Medicaid, for nursing homes. But we don't actually do that until there's a nursing home there.
Oh, okay.
And I hear a lot of people say, should we start giving our money away now? Well, I never recommend that. We don't know how long we're going to live, how long everything's going to be okay for us. And the last thing we want to do is really start giving our assets away. But what I tell our clients is that if that were to ever happen, your power of attorney should notify us so that we can protect the assets at that time.
That's good. That's very good advice. I never even thought about that, but that's a great idea to do. It does look like we do have another caller on the line.
We do. It's Joanne from Palm Harbor.
Hi, Joanne. Thank you for listening. Thank you for holding for a bit, too. We appreciate that. How can we help you?
Yeah, I had a question that if someone should die without a will, does everything go to the state of Florida?
That's a good question. If they die without a will and die without a living trust, Dennis, what happens?
Well, the state of Florida actually writes the will for that person.
So it sounds like it would all go to the state then if the state wrote it for them.
Not really.
Okay.
But again, the state would have to go through probate. So what's the will that the state writes for somebody? Well, if the person's married, obviously, it can go to the spouse. If there's children, the assets would go to the children. If there's no spouse, no children, and there's parents, it would go to the parents. If there's no parents, it would go out to the siblings, brothers, sisters, and that sort of thing. No siblings any longer, it'd go down to their children and keep going down.
So it has to go through a whole chain of relationships before it eventually goes to the state?
And it's still not going to go to the state.
Okay.
Some money will, obviously there's court costs and different things there.
You want me to call in like how much?
But the estate basically would go to whoever is in that chain.
Yes, does that answer your question for you?
But
thank you.
But it's always better to get just a will or something. Something's definitely better than nothing.
Right.
Okay. Well, thank you. I appreciate it.
Thank you for listening, and thank you for calling. We do appreciate it. All right. That does free up a line. We have about 13 more minutes here. The number is 727-441-3000. So if you have questions regarding probate, personal injury, we're here. Dennis Moses is here, and me, Matthew Noyes, for the law firm of Perronick, Caulfield, Averill, Illinois, are both here to answer your questions free of charge. So take this opportunity to give us a call and get your questions answered. So Dennis,
I've been doing all the talking. Let's talk about you.
No, I have to do all the talking all the other time. So I much rather talk about you because it's very important information. A lot of people, it's a topic that they don't want to talk about. They don't want to talk about, gosh, what happens when I die? And so this is a perfect opportunity and an avenue for you to give them advice. And even answer the questions that they may not even know that they have. You've been doing it for so long, you kind of know what situations could occur, and that's what's really good. You're good at answering the questions before they're even asked, because most people don't even know what questions to ask.
Well, it's really nice. Just about 100% of the time when I'm done with a client and we get everything signed, and they say, "You made this so easy. We've been stewing about this and thinking about it for years and years and years, and we never knew it'd be that easy." And it really is. So if you're going to go to an estate planning attorney, what should you be prepared to bring with you?
I was going to ask you, can you tell our listeners what the
So what I always tell my clients, just bring with you a general idea of what you have in your estate. You own a home worth so much in IRAs, 401ks, bank accounts, investment accounts, nothing in detail. That kind of tells us where we ought to be looking for the person and points us in the right direction, trust, no trust. And that tells us how to fund the trust once we actually do it.
And so there are situations where the situations may call that a living trust isn't the best way to go.
Like if there's no real estate, not a lot of assets, a will would work fine.
Okay.
But if even there's just real estate, it's the perfect way to keep the house out of probate is by way of a living trust.
Great. And so when they call you and say, "Hey, I don't know what I'm supposed to do," you meet with them.
That's correct.
And you go over all their assets and such.
But I tell you what, you ought to have a little idea of who you want to leave everything to and who you want to be in charge of the estate. I see so many times people come in, I ask the question, okay, who gets everything? Well, that's a really good question.
I thought you told us that, Dennis.
Yeah. Well, that's a good question. We need to think about that, okay? And then the next question is, all right, you die, who's going to be in charge of the estate? Well, that's another good question. So, if you're going to meet with an attorney, you probably ought to have a good idea what you want to do.
Right. And if it's husband and wife, the husband and wife should meet together because it's most of the joint assets.
Yeah. So like husband will say, well, yeah, my wife gets everything. Okay, that's fine. But what if she's not living? Oh, well, that's a good question then. No, we probably ought to have a backup. And whether it's a will or whether it's a trust, we have backup plans. Okay, so 50% of the estate's going to go to this person. Well, my next question is, well, what if that person's not living at the time of your death? Who gets that 50%? Well, then it should go to this person or whatever. And a lot of people really don't have anybody. No children, no family. So what can that person do? Well, if there's a church, charity, organization that person likes, they're very grateful to receive. So, there's a lot of good charities and churches. And
there's no way that if they had no will or no living trust, that if they wanted to give it to
That's
the
not
church,
where it's going.
it's not where it's going. You ran through all that list of the surviving spouse, children, grandchildren, grandparents, cousins, and all that other stuff. I didn't hear charity at all.
No, charity wasn't there.
So
if you have a church you love, that's a great thing to do. Give it to the church or a portion of it.
Right. Yeah. So the most important thing is what I'm hearing is you got to have a plan.
Got to have a plan.
Because that just really out of, courtesy to those who you leave behind, you don't want them to have to be making the decisions that you should have made.
That's correct. And what else should a person do? Well, if a person's getting up in years, to make sure that everything happens the way that we want to, well, there's other things we ought to do, like maybe pre-plan our funerals, burial, that sort of thing. You ought to think about what you would like to do. It seems like cremation's getting more and more popular anymore. If that's your desire, I always tell my clients, all right, when we finish up, at some point, you should visit a couple funeral homes or whatever and go ahead and get everything all set, because that's really nice for the families. When somebody passes and nothing's planned at all, it makes it really difficult, because that's not the time, the families, children, whoever.
They're mourning, they're sad.
Now they got to go through this whole process. And if mom and dad already took care of all of that, oh, good. So, they already know the name of the funeral home, call them and they'll take care of everything and they don't have to worry about anything.
Yeah,
a little bit of pre-planning and everything works well.
That's why it's not just wills and estate; it's estate planning.
Exactly.
The planning is the important word in your area of law. Yeah,
exactly.
So, can you give us reasons why somebody wouldn't want to do a living trust?
I get that question all the time. Well, why would anybody just do a will? Why not? Why shouldn't everybody do a living trust?
Yeah.
Well, that's a good question. I don't know the answer to that. We think the living trust way is the way to go. It's the best thing for us. Takes care of us during our lifetime. Takes care of us through incapacity. Takes care through death. And if there's going to be some provisions in the trust where it's going to go out over a period of time or whatever, it takes care of that as well. And even in a trust, it's handled so much better, especially if there's minor children involved. And I always get questions, from young people. Well, I don't have anything. Why should I do anything? Well, you got your children, right? And aren't they the most important asset for you? Most of the time, yes. And so, in a will, we can provide for guardianship. So if somebody, God forbid, dies, we have provisions in there who's going to raise the children, and a backup or whatever.
And that's in a living trust.
That's actually in a will, whether it's a pour-over will or a regular will.
Okay.
That's part of a will.
Okay. That's interesting. And so it gives it gives them guidance of what to do once that person is no longer with
And
you.
the second part of that, if there's a minor child involved and that person does have a living trust, according to the trust agreement, minors can't inherit. So you can't just give a minor a bunch of money or a bunch of assets, whatever. So in the trust agreement, it says if there is a minor involved in the distribution, it's up to the trustee to hold their share in trust for them to become of age 21 or whatever age you want. Except the trustee has discretion to use the minor share for educational expenses, getting him through college, special needs, things like that. So it works very, very well. And a lot of parents come to me, my child just turned 18. Do they need anything? Absolutely. That child is not a child any longer. That person's an adult when they become 18. So at a minimum, probably needs to have a durable power of attorney. That child's going off to college or whatever, probably want to give mom and dad power of attorney. So God forbid they get in an accident, something happens to them, mom and dad can take care of things for them. But even making medical decisions at that point, they can't.
Well, no, I had a legal assistant whose daughter turned 18, and a month before she turned 18, she was able to go to the doctor's office and listen to what the doctor had to say and give advice and give input. A month after she turned 18, she wasn't allowed in the appointment anymore because she just wasn't allowed to share that information with the mom since the daughter turned 18.
So the bottom line, it doesn't really matter what age. When you become 18, there's certain things that you should have, just to protect that person in the event of an accident or, deaths do occur still. And just to make sure that we have everything necessary that we can move on should that person become incapacitated, disabled, or whatever.
And we talk about the trustee, and it sounds like there's a lot of responsibility and a lot of power too with that trustee.
But the trustee has to follow directions, though.
Right.
Yeah.
Is there such thing as a professional trustee, or is it a family member who may be responsible financially or responsible?
Yeah, so who can serve as a trustee?
Yeah, who's best to serve as a trustee?
Anybody that lives anywhere can serve as a trustee. There's certain restrictions who can serve as personal representatives in wills. Personal representatives need to be husband or wife. They need to be blood related, or if they're not blood related, they need to live in Florida. But with a trustee, it can be anybody, no restrictions at all. So, if the person has a family member, child, daughter, son, whoever, that's great with finances, that makes sense.
Right. But it will always be mom, or I'm going to say mom, and the husband and wife. And if the husband should pass away, then the wife just takes over. But it's after the wife passes.
That's correct.
That's when what kind of trustee was that?
That's a successor trustee.
Successor trustee. Dennis was always much better with the legal words than I was in law school. And
that's not true. That's not true.
Oh, goodness. Well, Dennis, we have just a few more minutes left of this hour. This is FLA Law on the radio. I think, Dennis, you were a guest on FLA Law a few times, I think.
I was. It was a wonderful show.
Yes, and so I'm
helped
glad.
a lot of people.
I'm glad you're on FLA Law on the radio. I'm sure we're going to get you on here again. But can you tell our listeners just, 2 points that you say, gosh, this is what I want you to remember if you don't remember anything else from this hour?
Yeah, if you don't remember anything else, just remember something definitely is better than nothing. If you don't have an estate plan in place, get something. Because, the last thing that you're going to want is the state of Florida actually writing your will for you, because it's not a will that most people would choose for themselves.
Yeah, and if listeners want to reach you, how can they get in touch with you?
Yeah, we don't charge for consultations. If you're just totally confused, don't know what you need or whatever, we don't charge. So if you have a question by phone or whatever, call us. We don't charge for any of that either. You can reach me at 813-788-8677, extension 302.
And you have offices throughout Tampa Bay.
We do.
Yes. And so
we have offices in Zephyrhills, Trinity, Largo, Lakewood Ranch.
And the website is? Do you know?
www.attypip.com.
That's Dennis Moses, a good friend and a great attorney. If you have questions, please feel free to reach out to him. This is Matthew Noyes. We're wrapping up this week's show. Next week, we'll be here with my partner, Brian Caulfield, and myself, being able to answer any questions that you have regarding personal injury, medical malpractice, Social Security, disability, and workers' comp. So in the meantime, drive safely and watch out for those who don't. Take care.